Yeah, Lordship. Lordship, I'd like to mention item number 3. I've taken the consent. I informed the opposite party also. This
Let the
matter
matter
may.
reach. Let the matter reach. Let the matter reach. We'll consider your prayer. Number one. So earlier there was already a judgment passed by the.
My lord, I have brought
Now,
that
yes,
judgment.
we have gone through that. Now also please come to page number 81. The same issue has already been taken care of. Page number 81, your writ petition. 81. Turn to page number 82, first paragraph.
Yes. Yes, my lord.
So kindly read
81, my lord.
81, the order starts. Kindly come to page number 82, first paragraph.
Yeah. 82. After examining the records and on perusal of the materials pledge report is called, as well as upon consideration of the affidavit report to above, the court is of the view that creation of the Siang district and establishment of headquarters appears to be a policy decision of the government of Arunachal Pradesh. And at this stage, this court is not inclined to interpret with the said decision.
So it is clear.
Yeah,
If you read the judgment, the earlier judgment, reported judgment, and this particular paragraph, it is a policy decision of the government, and the court in exercise of the power in appeal will not interfere.
Yes, my lord, beyond that, my lord, because 2004 decision, that is against the shifting of headquarters, my lord. But our plea at this stage is to implement the decision passed by the government themselves, my lord.
Why don't you challenge the decision of the government of India to having its capital at Delhi? It should be the heart of the country, somewhere in Madhya Pradesh or in somewhere in a. You should have challenged it.
My lord,
Why you are not challenging them? See, that is the reason we are talking about.
My lord,
It is, in the historical, there was a king Tughlaq. Why he was called Tughlaq? He was famous for what? Right? So, things are like that. It is the policy decision of the government.
But my
You
lord,
have seen the report, the joint committee report, right? Where they have found what is available, what is not available, where the government have to spend much amount of money, where it is not required. So they have come in that way.
my lord, but beyond that,
Where is
there
the
was
illegality? How we have challenged that order? Where is the illegality in that order?
some direction.
So there has to be some violation of rules or something for that purpose.
My lord, so beyond that, some direction was also there, my lord, passed by the honorable court. May I read that, my lord?
So basically, as a read court, we cannot interfere in such policy decisions of the government.
But
That much.
they were, my lord, directed to dispose of the representation.
That is not the issue.
Yeah.
For that purpose, we will not interfere. If it is not disposed of, they will dispose it of, that much. But we cannot consider that the decision of the policy decision of the government
Lordship,
to be the headquarters.
they have disposed it of, but now fresh cause of action has arisen, my lord.
What is that fresh cause of action?
That is, my lord, they, in compliance with the direction passed by this honorable court, my lord.
You file contempt.
Yes.
You file contempt. Not compliance, file contempt. That's all. Will not interfere in such matters. The court has many other things to do.
But my lord, the people of those areas, my lord, equally deserve to be.
Whether Itanagar is in the heart of the Arunachal Pradesh. Whether Itanagar is in the heart of the Arunachal Pradesh. We are not challenging the decision of the government to have its capital at Itanagar. Whether Guwahati is the heart of the Assam, it should be somewhere in Sivasagar. If that way the capital has to be considered. But why Guwahati? But this is not the decision of the court to interfere, it's just policy decision of the government.
My lord, in 2004, my lord.
You have many other good cases to argue, not in these kind of cases. This is not an issue where the court should decide. It's up to the government to decide. Their elected leaders. That's all. We will not interfere in such matters. And thereafter, what we have seen, there is a decision. They are inquired into the matter. They have found out that, well, what land is available, what amount of cost will be required, why that particular place has been selected. You have to establish your case first. But while going to this PIL, we have not found any such decision, any such illegality in terms of that all.
Because
If the decision of the government is arbitrary, then you tell us. But there is, you are agree because your place has not been considered. The other place has been considered. That cannot be a ground.
well, I
You have
arbitrarily
to tell us where is the arbitrariness on the part of the government in deciding that particular place to be the headquarter of the particular district, new district of Siang.
arbitrary, my lord. The headquarters is smoothly functioning at Pangan for 4 years, my lord.
It was functioning as a temporary. That's the notification.
But the
That's the
report,
notification. Oh, anyway, please come to tell us. Come to page number 41.
yes, my lord.
Read 4A. Or in that case, it is Siang, right?
Yes. This is notification, my lord. 24.
Page number 42.
Well,
Section 5.
hmm,
Read section 5.
section 4. On and from the appointed day when Arunachal Pradesh Reorganization District Amendment Act 2013 comes into force, so much of the areas comprising the following administrative unit under the existing
Okay. Come to
Siang-
straight to the last paragraph of paragraph 5.
shall be transferred from East Siang and West Siang district respectively, and henceforth shall be constituted as a separate administrative unit and be known by the name Siang district with its headquarters at Nyovo.
So as per paragraph 5, it should be from which date? It should be from which date?
From the date of notification.
On and from the appointed day.
Yes, ma'am.
Paragraph 5, first line.
Hmm.
Now we come to paragraph 2, page number 41.
In subsection 2 of section 4 of the Arunachal Pradesh Reorganization of District Act 1980, herein of the referred to as the principal act, for the words figures and brackets subsection 1, 3, and 4 of the section, the words figures and brackets subsection 1,
No, 2, only 2.
2. It shall come into force on such that as state government by notification in the official gazette appoints, and different dates may be appointed for different administrative districts.
Now, please come to page number 44.
In pursuance of section 1, subsection 2 of the Arunachal Pradesh Reorganization District Amendment Act 2013, number of 2014, the Governor of Arunachal Pradesh is pleased to appoint the 24th of November 2014 as the appointed date of coming into force of the said act in respect of Siang district, as provided in section 4 of the aforesaid act, with its temporary headquarters at Pangin, till the construction of permanent structure at Nyomo, Perang, Lampang.
So that has not yet been notified. That has not yet been notified. Only the Siang district has been notified, and it is a temporary headquarter. It's not a permanent headquarter. Is
But-
there any notification regarding any permanent headquarter in the particular place which you are challenging? Is there any notification?
No, my lord,
Is there any notification?
No.
No. Then how your case will come? How you are affected?
My lord,
How you are affected?
because the
Where
headquarters.
is that notification? For permanent headquarter? As required under the law.
But cabinet decision is there, man.
Cabinet decision is the appointed day. You have just read. The same provision is also there in the 1980 Act. Arunachal Pradesh State Reorganization District and the Reorganization Act 1980. Same provision is there. Volume 2, Arunachal Pradesh. What we just found out is there. It may be under 3 also. Let us see, PMC. Volume 3 of
Yes, Mr. Council, you said that there is arbitrariness,
Yes.
but only arbitrariness will not do. It must result in violation of some right. Where is your right that it should be constructed or it should be declared in this place, not in that place? These are policy makers that can be agitated somewhere else, not here.
But
The elected representative, they have decided in a proper manner, procedure is followed, law was enacted. So you cannot say only for the reason that some person will have difficulty during the distance. You cannot.
so, my lord, we prefer to exclude our from that new district. So
That
that
they have refused,
yes, my lord.
that they have refused.
But while refusing, my lord, some observation has been made, my lord, and they have not not implemented the decision taken by
It is
themselves.
not there. And so far it is in the implementation, so can we monitor in a PRL that these are the decisions you will have to do this, do that, and we would not like to issue a futile writ. We'll pass an order that do this and that cannot be monitored or executed by a court. That is not possible.
My lord,
That is what I am saying, that can be, you can give the reply to your elected government somewhere else, not here.
how can you direct places, the decisions they have taken? Last week, we have taken a decision in one of the PIL. The matter relates to Arunachal Pradesh, but we have delivered our judgment in Guwahati. Go through the judgment, you realize where is the power of the elite court to interfere. And in that judgment of 2004, it is very clearly written. We cannot interfere in such decision of the legislature. That is the three different. That we cannot take that decision. We are going to dismiss it.
my lord, in that case, my lord, this PL may be closed with the liberty to file contempt.
We have no liberty. You can withdraw. You have always a liberty. There is no required. We are not. If you are withdrawing or not deciding on merit, right? In that case, you can always approach. We will not do that. We will dismiss it or up to you to withdraw. The reasons are there. You read the judgment of 2004.
Yes.
Justice Lamare has taken everything. Everything is considered. What else?
My lord, my plea and interpretation is that this 2004.
See, whether you want to be excluded from Siang district, it is again decision of administrative decision. How we can direct in a PIL that you should remove all these district from Siang, all these places from Siang, you have to incorporate in particular district or neighboring district. Can we direct the administration? It's a legislative decision. Can we direct? Just think over, Mr. Modi, with your experience in the bar. Can we direct in exercise of the power under Article 226? If we start taking such decisions, there will be no required of that.
My lord,
You understand?
Yes, my.
So now you tell us whether you dismiss it or it is up to you to withdraw.
I may be allowed to withdraw, my lord.
Heard Mr. Nalopadal and counsel appearing for the petitioner. And Mr. Navam, an additional advocate general, Arunachal Pradesh, appearing for the state respondents. On instruction of the petitioners, Mr. Padal and counsel is not pressing this bail. Accordingly, this bail stands closed.
Obliged, my lord.
Someone has been pointed as for two, I think so.
What?
As per office note, dated 19/2/25, condonation application was not yet filed.
No, no, on 21/2/2025, it was condoned. Condoned.
Delay.
Yes,
There is a provision to condone
Yes.
delay.
It's a,
Jail appeal because he is in jail, he
Jail.
cannot.
yes.
It is in the help of the jail authority, that's why it was
Yeah.
condoned.
And
Now,
I,
question is that the LCR. is-
LCR not received, yes.
By order dated
21.
21/02025, Tarakote লিখিব। Heard, as B. Dharan, learned legal aid counsel for the appellant. And Mr.
Jita though.
Learned additional public prosecutor appearing for the state. Paper book মোটামুটি
Three zero two, might.
This appeal was admitted. This jail appeal, this criminal appeal from jail was admitted by order dated 21/02/2025. It is seen that registry has also received the records in original from the Court of Learned Sessions Judge, East Sessions Division, Teju, District Lohit, pertaining to part 1, part 2, part 3 number which were
Your lordship, teaser already received. TCR is there.
Please take your seats. Please take your seats. Okay, he did the second part. Pertaining to Sessions case number 10, putting bracket NMS oblique 2020, arising out of Namsai Police Station case number 46 oblique 2019. Registry shall prepare the paper book and on its preparation shall submit a copy of such paper book to Ms. such and such, Honorable Legal Aid Counsel for the appellant and Honorable Public Prosecutor, Arunachal Pradesh. List on second of June for order for fixing a date of hearing.
Also, Lordship, today this matter is listed wrong. Actually, this is supposed to be listed on 7th of May because there is some another matter also is fixed. My senior counsel will be appearing from the Guwahati.
Yes. Well. Okay. On the prayer of the counsel for the appellant, list on 07052025 along with the connected matters.
Much of it.
Mr.
Please,
Singh, you
Your
have heard the
Lordship,
item number 1.
Yes, Your Lordship, that is why
So,
I was following also, Lordship.
so
Uh,
same judgment will follow.
Lordship, here the problem is that this senior counsel has already been engaged in the present case, Your Lordship. So,
Question of senior counsel and junior counsel doesn't arise.
I-
Where the matter issues involved in this. PI,
yes,
right?
that
Whether you can interfere in such matters or not. That's all.
there are actually some,
The
In the-
prayers that you have made,
yes, Your Lordship.
can you pass those orders?
This is regarding policy decision of the government. Uh, Where the district headquarters was shifted from Jamin to Pali.
Are you,
After
are you
developing,
pressing, are you pressing prayer number A? Are you pressing prayer number A, page 44?
in that case, because I cannot take any decision here in the matter without the consent of the senior counsel, Lordship. May I pray that this matter will be listed next week, Your Lordship, next week, so. Then come.
Whether the
Because-
senior council appears or not, doesn't appear, you have to tell us and you know the outcome,
Yes,
right? Now you are
Next
aware of the
week.
outcome.
next week, Your Lordship.
Monday
Lordship.
next.
Yes.
Declare of Mr. Rekha. Let's start from the next.
I'll inform the Lordship.
May I please, Lordship? Lordship, here I am appearing for respondent number 3 and 4, Lordship. Lordship, here we are to file affidavit in opposition, Lordship, and we are waiting instruction from the department, Lordship.
You are appearing for whom?
INC, Lordship, 3 and 4, respondent number 3 and 4.
6. When did you appear in the matter? When
Lordship.
did you appear in the matter?
Lordship, actually, there was miscommunication between us in with department, Lordship. Lordship, our name was not reflected in the cost list in many occasions, Lordship. So, Lordship, in previous occasion, I have requested this.
Mr. T. Omo.
Tijamo, Lordship. Tijamo, I am for Tijamo, Lordship.
Therefore, it is.
Lordship.
Now, he is representing the respondent numbers 3, 4 and 6.
3, 4 and 6, Lordship.
Now,
2 and
notice
5.
was received by him on 15th of June 2023. Right?
Lordship.
Now, tell us what is the reason that we should consider your prayer to grant you time to file affidavit? You have not followed the provisions, that is the claim. It is very specific how such amount has to be distributed, what is the procedure to be followed when this contract is above 50 lakhs, less than 50 lakhs, and everything is there. Right? Now, question of giving you instruction will not rise now. If you want to file your affidavit, you can file it by this Friday, not beyond that. That much we can do. We will not consider. It will be listed on Monday.
Lordship,
Just 1 minute. Come to page number 80. Kindly read. Agenda 4.
Lordship, paragraph 20, Lordship.
Paragraph number. Agenda 4, page number 80. So have you followed this? That's the issue. Have you followed it?
Lordship, kindly may be given 2 weeks for last
Question of
test, Lordship.
renting, question of 2 weeks will not come. Notice was issued in June 2023, Mr. Counsel.
And Lordship,
We cannot grant you time. If
And
you
Lordship-
want to file your affidavit, you file it by.
Lordship, I am appearing on behalf of Tijamo, Lordship.
Whoever, doesn't matter. Let
And
Tizamu come from
Lordship,
somewhere, some satellite or something, we do not know.
Lordship.
Tizamu is only a council, the respondents are there. an amount of rupees 12,197.80 crores sanctioned to Itanagar Municipal Corporation for development of capital complex Itanagar by Itanagar Municipal Committee. Itanagar Municipal Corporation. It is alleged that violating all the provisions of law, the Itanagar the respondent, Itanagar Municipal Corporation, willfully misused the public exchequer in the name of developing the councils under the Itanagar IMC related. Notice in this case was issued on 15/06/2023, and thereafter the respondents in the Itanagar Municipal Corporation took time but not filed their affidavit till date. A last chance is granted to the respondents number 3, 4, and 6, Itanagar Municipal Corporation, to file their affidavit on or before 05/05/2025, list on 06/05/2035. Failure on the part of the respondents in the Itanagar Municipal Corporation to file their affidavit on or before 05/05/2025. This PL shall proceed ex parte against those respondents.
We have letter.
Too bold to read on.
May I please, my lord? My lord, here, respondent number 6 is yet to file their affidavit. And I've taken steps.
Payroll the office note dated 25/04/2025. Registry received back the service report after the service of notice on the rest number 4. As sorry, rest number 6. As service is complete, place this matter for admission on 6th of May. Seventh of May.
Sir. Acha.
Your Lordship, the leading counsel is attending the Supreme Court matter. Kindly any fixed date may be given.
What's your good name?
Y Singhi.
This is also 302, read with section 27 arms. And she is for private hospital.
Namila Pradigo. It is seen that this preliminary appeal was already admitted on 01/05/2024. Registry has also prepared the paper book and served these copies on the counsel for the appellant as well as the respondents. Place this matter for hearing in its usual court.
Oblige your Lord.
Issue reminder, Wednesday office note dated 24/04/2025. Issue reminder. To the office of the learned special judge, in bracket POXO, cum session judge, East Siang district, Pasighat, Arunachal Pradesh, for the original records of PSG space bar SC, within bracket POXO case number 11/2021, arising out of Rumgong police station case number 10/2021. That was called for by called for by order dated 11/09/2024. List on 28/05/2025. On the same day, the officer in charge of Rumgong Police Station, District Siang, shall apprise the court about the service of notice of this criminal appeal. The respondent number 2 / informant of said Rumgong Bias case number 10/2021. This order will be the notice of the register. Ownership of this photo. Itanagar Municipal.
I didn't know that.
Just tell us one thing,
My lord.
whether in this case award was passed or not.
No, my lord.
Award was not
No,
passed,
no award was passed.
but the assessment was made under the
Correct. And my lord, the decision relied upon by my lord, the honorable single bench, authored by his lordship, that is under challenge before the Honorable Supreme Court of India, my lord, on being SLP prepared by the state government.
whether,
Basing on, yes, my lord.
whether it has been numbered and any order has been passed under this.
My lord,
What order has been passed?
That is state, madam.
Where is that order? Have you annexed?
Madam, I'm sorry, madam, I have not given the copy of that. Therefore, madam, this is
Oh,
this.
the earlier judgment of Justice Burua.
No, Justice Bukan, Honorable Justice Bukan, madam.
This order, which is implemented in the connected appeal.
Madam, may I take your lordships to the impugned judgment order and passed by his lordship, Justice Bukan. Main appeal, madam, page number 49, madam, Ereksha War, 49.
That we have seen. Because in the other case, it was already considered and given.
But this judgment was challenging division bench.
Yes, ma'am. And division bench,
That my lord justice, and justice.
correct, ma'am.
Now that is pending in Supreme Court, where there was a status order,
Madam.
not stay, status order.
Now this page 49,
Yes, ma'am.
this is the improved judgment, right?
Yes, ma'am.
Against this, you have preferred it appeal. Against this, you have
Madam,
preferred.
in this case, we are not party, madam.
Where?
Madam, this, yes, madam, this present appeal is against this order, madam.
So it was already upheld by a coordinate division bench, which is pending before the Supreme Court now.
Madam, madam, may I submit, madam?
But thing is this, please come to page 49. You are a party.
Madam, for this
Page
page,
49, serial number 45.
last page, madam, operative portion is page number 53, madam. 54, sorry. As issue of the entitlement of solution and interest has already been settled in the Mihin Laling case Sufra, as discussed above, this court is of the considered opinion that the case of the present petitioner is covered by the decisions of Mihin Laling Sufra, and he is entitled to the same relief granted in the aforesaid writ petition. Madam, for a moment, I'll pause this. Madam, in Mihin Laling case, the state government has prepared a SLP before the Honorable Supreme Court.
Particularly was in a written literate. Yes. That
Yes.
is a so therefore,
Yeah.
ultimately, that the foundation of the judgment is under challenge.
Correct, madam. Correct, madam. And more particularly, madam. So therefore, madam, at this stage, madam, my condemnation may be, madam, delay may be condemned, madam. Let us wait for the outcome of the, madam, the SLP, madam, pending before the Honorable Supreme Court, madam. Other is also, madam, direction is to the state government for payment of the solution and interest, madam. We have already paid the compensation amount to the petitioners and, madam, whatever it was entitled, that has already been paid. By this judgment, madam, amount has to be paid by the ITBP again for the, madam, the same plot of land which has already been paid, inclusive of all, madam, interest plus solution, madam. That is the whole, madam, the contention.
This was for transnational highway or for what purpose? Border. It was taken by IT on behalf of ITBP.
Border.
Border roads.
Border outpost.
Border outposts.
I have nothing to say, whether the condonation or a plausible explanation has been given or not. Because 71 days is not,
So,
a week
but
or.
these matters relates to public exchequer. Right? Or involvement of ultimately public money is there.
The explanation, the lordship will see what kind of
We
explanation.
have seen that.
That's all,
It's
Malad.
better for you that the age condone and
Yes.
Your
Well,
conversation
I'm
is only-
just pointing out that part only. That's all.
Heard Mr. Matu Katu, learned Deputy Solicitor General of India, appearing for the applicant. Who is appearing for the state? From Mass Census. Learned Council appearing for the state respondents on board. Two, three, and four. 2, 3, and 4.
Yes.
Paragotali. And Mr. D. Kamdu. Not D.
Apitapur.
Apitapur. Learned Council appearing for the respondent number 1 at each.
Yes,
right?
sir. Respondent.
One only.
Land of the respondent number 1 was taken over under the Resume Cultivation Act for construction of border outpost of ITBP at which village?
Rubber village. REBE.
Siang Tajo.
Chang the job.
Siang Tajo is coming district.
Rubber village sample.
Is coming.
Yes.
However, as the district collector, while determining the compensation for the land compensation, did not assess 100% solicium and 12% interest as per the provisions of Act Contrary. He preferred the connected writ petition being WPC number 56/2023. Learned single judge by judgment and order dated 13/06/2023. Following the decision of a division bench of this court in the case of Mihin Lalin decided on 25/04/2022 in lead appeal number 15/2022 arising out of WPC number 280/AP/2020. Directed the Deputy Commissioner, the state respondents, including the district collector, Siang district, to grant solicium interest upon the compensation already determined payable to the respondent number 1/30 petition for taking over his land or establishing the border outpost of ITBP. Agree by the same, Chief Judge, remember, the one single judge. dated 15/06, 13/06/2023, passed in WBC number 96/2023. The applicants and appellants have preferred an appeal the delay of 371 days. Hence this application, or to condone the delay of say 371 days. The respondent number 1 filed its objection with regard to the delay of objecting as an affidavit, objecting such condonation of the delay. Stating that the applicants did not give the exact dates as to when they considered to prefer the connected appeal. After hearing the learned counsel for the parties and they considering the materials placed in this application, we found that the applicants could give sufficient reasons for the delay in preferring connected scheduled appeal, considering entire aspect of the matter. Delay of 371 days in preferring the connected appeal by the applicants against the judgment in order the 13/06/2023 passed by Learned Single Judge in WPC number 56 of 2023, preferred by the respondent number 1 is hereby condoned. Registry shall accordingly register the connected.
Already registered.
Wrong. Registered and list the same for admission on the 5th.
Till such time, madam, till such time, madam, this order may be, madam, still.
That will be considered on the 5th.
Madam.
Not considered.
Another IA, madam.
Another I
Yes, for stay of the, madam, the.
That will see on Monday. It's
Madam.
not now.
Different.
Yes.
Yeah, your lordship.
Mm.
Yeah, so I beg to mention item number 17, your lordship. This,
17.
yeah, this matter to be listed after 1 week, your lordship.
Okay.
We have not received instruction, your lordship.
This is matter fifth occasion whether they are seeking time.
No instruction is required. You'll have to decide whether, what is the position.
On the first day, till my lord has so
Ah.
record my.
Hmm.
At least
You
1
want the
week, your
record,
lordship.
huh? When?
1 week, your lordship, at least 1 week time will be
Next
given.
Tuesday, madam, on that day, madam, you must produce the record, madam. If you not file-
Next Tuesday?
Okay, your lordship.
On the prayer of the learned counsel for the state respondent, may trust stands adjourned to facilitate her to produce the record in terms of this court's earlier ordered, that first order, I think.
28, 1/2025.
28 on 2024.
Obligation.
Bless your lordship.
May I, Lordship? Lordship, item number 9.
Item number 9.
Yes, my lord.
Yes.
My lord, I would, this matter may be list on 6th of May. I'm 6th of May. I'm from the respondent side.
Lordship, I am for the petitioner. There is an interim.
Huh.
That interim may be continued,
Okay.
Lordship.
6th, on the prayer of the respondent, on 6th of May, interim order passed shall continue till then.
Much obliged. May I, Lordship? Your Lordship, I beg to mention item number 6.
With the consent of the other party, Your Lordship.
Item number
6.
6. What was the earlier one? Okay, 6.
Your Lordship,
Yes.
this matter may be posted for tomorrow, Your Lordship.
Tomorrow?
Yes, Your Lordship.
Not tomorrow, next week give a date.
Or maybe day after tomorrow, Your Lordship.
Huh?
Yeah, day after tomorrow.
Day after tomorrow is a Friday,
Thursday.
Thursday, okay. Day after tomorrow.
Yeah, please. Item number 20.
20?
21. We take it up day after tomorrow. My friend for the other party expressed the difficulties for today.
Okay, 21, day after tomorrow.
Yep.
Second evasion.
All right.
My lord, I beg to mention item number 8, my lord. My lord, here we require to file the affidavit, my lord. The instruction I have not yet received, my lord.
Okay.
Can this matter be released after 3 weeks, my lord? I've taken consent from the
Okay.
AKC, my lord.
The standing council for the
Education
department praise for and is granted 3 weeks time to file his affidavit.
deeply obliged.
Please accordingly.
Lordship, item number 7. I'm put a petitioner here. This matter may be fixed for hearing on the next occasion.
When?
After 2 weeks.
On the prayer of the learned council for a petitioner.
Yes, for a petition.
Matter stands adjourned and will be listed after 2 weeks. Yes.
May it please your Lordship. Lordship, this is an application under section 482 of the BNSS.
We'll keep the file. Heard.
Application under section 482 of the BNSS, Lordship. At the outset, my lord.
Notice interim. Huh? Appear before the IO within 10 days to record his statement.
Can it be 15 days, my lord? if
15
possible?
days, within 2 weeks. Give a date for a case diary after 15 days.
May, Lordship.
14th of May. Next date is fixed on 14th of May.
14.
You appear within 15 days before that.
My lord, I'll
To record your statement. Interim, there will be interim.
And
Yes.
Lordship, along with the statement, Lordship, which they have. Lordship, yes.
You'll have to,
Yes.
case that, you'll have to appear, we want your statement.
Yes, Lordship.
All the records, Lordship, they have submitted.
You appear, give whatever you
Yes,
record.
Lordship.
Nothing is there.
Yes,
This is a commercial transaction. Not the single whisper that he has initial deception in mind.
Yes.
Or that there was a sitting. Simple thing is that he sold me a bad vehicle. So that's all.
No vehicle, no Lordship, this is.
Supplied
different,
some
Lordship.
Some, not vehicle,
Yes.
some shade and all this
Yes,
for
material.
construction of some restaurant and all.
Renovation.
Yes, Lordship, as per the FI, Lordship, the total this, that lady, Lordship, they have already, Lordship, payment of 5-6 lakhs, Lordship. From there, Lordship, only 5 lakhs. Yes,
Everything is
Lordship.
there,
Have
but
repaid
where is the criminal kind of
Yes, sir, but
thing?
if-
It's a civil dispute.
Yes,
Civil
Lordship.
dispute.
If they have not cooperated, then it's.
Let
Yes,
them cooperate. That is what I'm saying. That's why I'm
Yes,
interested.
Lordship.
You appear, give your statement.
I'll cooperate, my.
Yes.
Highly obliged.
Otherwise, we'll recall this order on the next day.
Highly obliged.
Obliged, Lordship.
After this matter, this will be passed over for the day matter and seek some instructions from the client. Madam.
Okay.
Tomorrow.
Tomorrow? Okay. On the pair of the right council for the day after tomorrow?
Yes, no, but
Tomorrow.
subject to
Okay, okay. On the prayer of the learned council for the petitioner, place this matter again tomorrow to complete his instruction.
No, Lordship.
Yes.
Here in the case, I am challenging the transfer order, which was passed on 8/4/2025.
Where is that?
That is page 18, my lord.
Page 18.
Page 18. Yes. If any employee who is holding a post of transferable, in that case,
being an employee, he must go. But in any transfer, it should be always in public interest and education of service. Now here in the case, in the impugn order, there is no mentioning of the public interest. There is no mentioning of the education of service. In the remark column, what it is said, at his own request, that is serial number 1. In
Where
the
is,
remark
where is on request?
Huh?
Where is on request?
Remark column.
Remark, first
Remark,
move
yeah.
on his own request.
At his own request. That means whatever transfer.
Yes. Art, Mr. Swenso learned senior counsel assisted by Tapa, learned counsel. The petitioner who is a driver, who is a driver and presently posted at, where is it? CHC Tooting, isn't that it?
Yes. Community health service.
CHC Tooting, and has challenged an order of transfer dated 8th of April 2025, whereby he is sought to be transferred from CHC Tooting, within bracket his present place of posting, to CHC Mariang, MARIYANG, Mariang, full stop. Have you made this respondent a party?
Yes.
Parang, respondent number?
4.
Respondent number 4.
4.
The learned senior counsel, referring to the impugn order, contends that the respondent number 4, who is placed in the present place of posting and transferred from CNC Mariang, was on his own request, and therefore, without there being any disclosure that the transfer was in public interest, it is in the private interest of the respondent number 4. Full stop. This matter needs further consideration. Issue notice, return. You are still in the Tooting? Sure? Any statement in the petition?
Yes.
Where is the statement that you are still working?
Yeah, we have submitted the written
Any statement that you have not, huh?
Para number 8.
Paragraph number?
Yes, para 8.
Para 8. Okay, considering the aforesaid, considering the matter in entirety, this court is of the view that the petitioner has been made able to make up a case, prima facie case for an interim order. Accordingly, it is provided that till returnable that the impugn transfer order dated 8th of April 2025 shall remain suspended. Returnable on?
After 2 weeks, madam.
That give a date after 4 weeks. Give a date after 4 weeks.
4 weeks.
Give a date after 4 weeks. 3rd of June 2025. Full stop. On the next date fixed, the learned sending council. You are for
Health matter.
Health Department of Health shall keep the record pertaining to the impugn transfer order ready for perusal of this case.
Your Lord. So this is for the revocation of.
Yes, who is for the tax?
My lord, I am appearing on behalf of respondent number 2 and 3, my lord.
You can dispose it of?
My lord. You can dispose it of, my lord.
Borrow this for standing council, civic and CS. Makato for
Union of India.
Union of India. Your name, please.
Zettaba.
Zettaba. Revocation of yes, disposal.
Shall you bless, my lord?
You take an order from no. Yes, item number.
Here, my lord, we have maybe please, my lord.
Yes.
Here, my lord, we have challenged the impugn order dated
Heard. You are Mr.
A.R. Borwa.
A.R. Borwa, Learned Counsel for the petitioner, and Mr. Kato for
Respondent number 1, 2, 3, and 6, my lord.
1, 2, 3, and 6. Who is 4 and 5?
My lord, rest are private individual, my lord. Of course, serving under the ITBP, my lord, but private.
1, 2, 1, 2, 3.
1, 2, 3, and 6, my lord.
1, 2, 3, and 6. Full stop. The present application is filed assailing an order dated. What is the first order?
The first order dated was
29/9? No.
Yes.
26.
First dismissal.
The first order is 26/10/2020, my lord.
26/10/2020. 26/10/2020,
And
and
bill was filed and then.
an appeal order dated
9/8/2022.
9/8/2022.
Yes, my lord.
An order dated first order whereby the petitioner was dismissed from service,
Removed from service.
removed from service. Full stop. The other challenge is an order dated 22/10/2022.
The other order.
Other-
9/8/2022.
9/8/2022, whereby such decision was upheld by the appellate authority. Issue notice returnable after 4 weeks. Mr. Kato accepts notice on behalf of respondent number
1, 2, 3, and 6, my lord.
1, 2, 3, and 6. Notice to respondent number 4 and
4,
5
5,
be
6,
issued to
7,
registered
8,
post
9.
with AD. Petitioner to take steps for such notice with issuance of such notice upon respondent number 4 and 5 within 5 days from today. Full stop. As Mr. Kato has appeared for the respondent number 1, 3, and 6, no formal notice need be issued. However, extra copies be served upon.
Develop.
My lord, this is the Jilla Parishad chairperson, election of the key finance, my lord. My lord, here is that procedure is not maintained by the authorities. That is called the learned deputy commissioners and the additional deputy commissioners of some member secretaries of the key finance, my lord. My lord, here is that under conduct rules of the Panchayat Raj Act 2001 and section 67 clause 1 it clearly said that the deputy commissioner should be for the first meeting, deputy commissioner should be for the meetings initially. Thereafter, clause 2 says that deputy commissioner should conduct the meetings. After that, he may be appointed to some other officials for the business of the Jilla Parishad members. My lord, here is that the authorities is not compliant to the section 67 of the clause 1 of conduct rule of 2001. My lord, this is my challenging of the interim order of once interim orders of my lord notifications of that issue by the learned additional deputy commissioners. Initially, first, additional deputy commissioners has no call for the meetings. There is no any provisions, my lord, except the deputy commissioners for the initial meetings will conduct, my lord. Here is notification issued by the my lord is
now meeting is held already.
Yes, my lord.
What is your challenge here, basically?
Yeah, basically, my lord, here challenge is page numbers 30 at annexures C. My lord, please see. I selected this notification, my lord, whereas very short period during the holiday times, a notification was issued. There is no properly communicated with all the Jilla Parishad members.
You are challenging annexure C, page 30.
Yes, my lord. Another is that, my lord, here is two challenging is there.
No, let us understand first. Don't go
yes.
so fast.
Yes.
Let us understand what is this.
This one.
Decision.
My lord, I'm sorry to interrupt. My lord, we are appealing for respondent 4. We have filed our affidavit in opposition. All the relevant documents are there, and we will demonstrate that the procedure was followed. Anyway, so affidavit in opposition was filed today. So I hope, my lord, our copy is there available.
Yes, my lord. Today, this morning, I received the
filed by the senior councils epidemic. Now I ready to arguments in this regard. I received. Matter is very clear, my lord, as per the
No,
law.
no, you received, but I need to go through it. You received, you read it. I am not having the copy affidavit.
My lord, I ready to assist you, your lordship.
No, you will assist me. That's true. But without the affidavit before me, how will you assist me properly?
We have completed the filing this morning, my lord. We have sought for the requisition also from the registry.
Okay, we'll take it up day after tomorrow.
Day after tomorrow.
Very well,
Okay.
very well.
Day after tomorrow.
Very well, my lord.
It is submitted. The respondent number 4 has filed an affidavit in opposition. Same is not on record. Same be brought on record and list this matter again day after tomorrow. That is.
So day after, my lord, that is 1st of May, I believe. My lord, 1st of May, I think.
1st of May? 1st of May.
1st of May. Very well, my lord. Very well, very well.
My lord, here, my lord, on 27/2/2025, my lord,
Item number 11. Yes.
substantial question were already framed, my lord.
Why lower court record is not yet received?
Yes,
No?
ma'am.
Huh?
Yes, ma'am.
Trial court record of PSG within bracket Kebang appeal number 66/2022 has not yet received from the Court of District and Session Judge Pasigat registry to issue reminder. Anybody appears for respondent number 2?
No, I am 3.
You are 3.
Along with the, my lord, the record.
Await
my lord,
service report in respect of respondent number.
Along with this record of the court below, my lord, the Kebang decision, they should 7 to.
No, let it first come. We'll see.
For that, ma'am.
The list after 3 weeks.
May I please, Lordship? Lordship, I'm appearing on behalf of Mr. K. Posi. Lordship, I would like to pray for adjournment for Mr. K. Posi's out of station.
A prayer for adjournment is made on behalf of the petitioner. Prayer stands allowed. List this matter after?
After 3 weeks, Lordship.
After 3 weeks.
In this item number 13, this maternity is not there because this is represented by Monojit Vishwas.
Okay.
From Guwahati.
Okay.
And he requested me to take the matter on 2 May.
2nd of May. Okay. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on 2nd of May.
Lordship.
May I please, Lordship? Lordship, we would like to take fresh steps regarding this.
You want to take fresh steps?
Yes, Lordship.
The learned counsel for the petitioner prays for 5 days time to take fresh steps. Okay.
All right.
Upon respondent number 2, prayer stands allowed. List this matter after 4 weeks. If steps within 5 days are taken, otherwise list this matter again after 5 days.
Okay. Interim to continue. There's an interim here.
That's why interim to continue till the next date of listing. If you take steps, then it will come after 4 weeks.
Okay.
If you don't take within 5 days, it will come listed after 5 days. Then we'll vacate the stay order.
All right, Lordship.
Okay.
All right. Deeply obliged.
$16. Huh?
Yes. 16.
15 or 16? 15 was adjourned. I don't know. 15. This is 16.
Yeah, mine was 15. This is 16.
16. Okay.
So, SIP, in compliance of the order passed by the Sarvak Bondos, only the order has been passed. Copy also has been furnished to my friend.
So speaking order is passed for regulation. Yes, you challenge this, you are happy, if you are not happy. No provision for such relation of the post requested with them. The present contempt petition is filed alleging non-compliance of an order dated 22/7/2024 passed in WPC
278 of 2024.
278 of 2024. By the aforesaid order, this court directed the respondents to consider and dispose of the representations filed by the petitioner for regularization of their for regularization of their services due to resultant vacancy within a period of 3 weeks. Full stop. The learned counsel representing the sole respondent has produced and speaking order dated 12th of November 2024, whereby passed in pursuance of the aforesaid order, whereby the claim of the petitioners for regulations was rejected. A copy of the order dated 12th of November 2024 is also furnished to the learned counsel for the petitioner. In view of the aforesaid, the order dated so is thence complied with. Accordingly, contempt petition stands closed. Petitioner shall be at liberty to approach the appropriate forum if he has any grievance against the speaking order dated he or it, I do not know, grievance against the order dated 12th of November 2020. And an order, a copy of the order dated 12th November 2024 is also kept on record.
All right.
None appears for the petitioner on call. Matter stands adjourned and be listed after 3 weeks. Heard. You are Mr. H. Lampu, learned counsel for the petitioner. The present application is filed for implement of the present application is filed for implement of a new respondent.
Yes.
One new respondent.
Yes.
New respondent, namely Messrs. Kenewa KH is a C pastry. Namely
MSPP Sangvia.
Where is that?
My lord, page 2, man.
Page 2. Messrs. PPC page 2, pencil 1. Mr. Pepe Swensu. Such application is filed pursuant to this court's order dated 17/3/2025, passed in the connected writ petition, that is WPC 106 within bracket AP 2025. The coordinate bench in the aforesaid order has already held that the aforesaid enterprise is a necessary party. In view of the aforesaid, present application stands allowed. The aforesaid PP Sangviva enterprise be implemented as respondent number 4. The petitioner is to file amended cost title before the registry as well as a copy to the learned counsel for the contesting parties. I stands disposed of. Full stop. Then we'll have to issue notice to the respondent number 4.
My lord.
So we'll have to fix the list the connected writ petition
After amendment.
After amendment before this court.
Obliged.
None appears for the petitioner on call, though the respondent is represented. Accordingly, list this matter stands however, in the interest of justice, matter stands adjourned and be listed after 2 weeks. Pleasure.
सर आइटम नंबर 22 में क्या हुआ?